Welcome to Chapter 2, Overview of Data Protection Laws Globally. In this chapter, we explore the European Union GDPR, General Data Protection Regulation, U.S. Data Protection Laws, CCPA, HIPAA, comparison of GDPR with the DPDP Act. European Union GDPR, General Data Protection Regulation. Overview of GDPR. The General Data Protection Regulation, GDPR, is one of the most comprehensive and globally recognized data protection laws. It was adopted by the European Union, EU, in May 2018 and aims to protect the privacy and personal data of individuals within the EU. The GDPR applies to all businesses or organizations that process personal data of EU citizens, regardless of where the business is located globally. Key features of GDPR: scope and applicability. GDPR applies to any organization, public or private, that processes personal data of individuals in the EU. This applies regardless of whether the organization is based in the EU or not. This broad scope has made GDPR the gold standard for data protection regulations worldwide. Data subject rights. GDPR grants individuals several rights regarding their personal data. These include right to access. Individuals have the right to know what personal data is being processed. Right to rectification. Individuals can request corrections to their data if it's inaccurate. Right to erasure. Right to be forgotten. Individuals can request the deletion of their personal data under certain conditions. Right to object to processing. Individuals can object to certain types of data processing, especially direct marketing. Right to data portability. Individuals have the right to request their personal data in a machine-readable format. Consent. GDPR mandates that organizations must obtain clear, informed, and unambiguous consent from individuals before processing their personal data. This consent must be specific to a purpose and can be withdrawn at any time. Data protection by design and by default. Organizations must implement data protection measures at the start of any project involving personal data. This includes the minimization of data processing, limiting access to only necessary data, and ensuring that data is processed securely. Data breach notification. GDPR requires organizations to notify the relevant supervisory authority of any data breach within 72 hours of detection. If the breach is likely to affect individuals' rights and freedoms, organizations must inform them as well. Penalties for non-compliance. Non-compliance with GDPR can lead to hefty fines. The penalty for serious breaches can be up to €20 million or 4% of the organization's global turnover, whichever is higher. Impact of GDPR. GDPR has not only had a profound impact on the EU, but has also influenced data protection regulations across the globe. Many countries have adapted their laws to align with GDPR standards, and it has set a high bar for how personal data should be managed in the digital age. U.S. Data Protection Laws, CCPA, HIPAA. California Consumer Privacy Act, CCPA. The California Consumer Privacy Act, CCPA, came into effect on January 1, 2020. It provides California residents with significant rights over their personal data and applies to businesses that collect personal data from California residents, meet certain revenue thresholds, or collect data on a large scale. Key features of CCPA. Right to access. Consumers have the right to request details about the personal data a business has collected, including the sources, purposes, and third parties with whom the data is shared. Right to delete. Consumers can request that a business delete their personal data, with certain exceptions. Right to opt out. Consumers can opt out of the sale of their personal data to third parties. Non-discrimination. Businesses are prohibited from discriminating against consumers who exercise their rights under the CCPA, e.g. by denying them services or charging them different prices. Penalties. The CCPA imposes fines for non-compliance, especially for businesses that fail to respond to consumer requests. The fines can reach $7,500 per violation. Health Insurance Portability and Accountability Act, HIPAA. HIPAA, passed in 1996, is a key regulation in the U.S. that protects the privacy and security of personal health information, PHI. It applies to healthcare providers, insurers, and other entities that handle PHI. Key features of HIPAA. Privacy Rule. The Privacy Rule sets standards for the use and disclosure of health information, ensuring it is used only for specific purposes, such as treatment or billing. Security Rule. The security rule requires healthcare organizations to implement measures to protect electronic PHI, EPHI, ensuring it's safeguarded from unauthorized access, alteration, or destruction. Breach notification rule. HIPAA mandates that entities notify individuals if their PHI is breached. Penalties. Violations of HIPAA can result in both civil and criminal penalties, with fines of up to $50,000 per violation, depending on the severity of the violation. Impact of HIPAA. HIPAA has had a significant impact on health data privacy in the U.S. and has been an important regulatory framework for other countries focused on healthcare privacy. However, HIPAA's sectoral nature means it mainly covers the healthcare industry, unlike GDPR, which applies to all sectors. Comparison of GDPR with the DPDP Act. The Digital Personal Data Protection Act, DPDP Act of 2023, is India's key data protection legislation. While the GDPR and the DPDP Act share similar principles, there are several differences in terms of scope, penalties, and specific provisions. Let's compare the two. Key similarities. Data subject rights. Both laws recognize key rights for individuals, including the right to access, correct, and erase personal data, as well as the right to withdraw consent. The right to data portability and to be informed of data processing practices is another common feature. Consent requirement. Both GDPR and DPDP Act require that organizations obtain explicit, informed, and freely given consent from individuals before processing personal data. Accountability and transparency. Both frameworks ensure that data controllers or data fiduciaries in India are accountable for lawful processing of data, and transparency is required in how organizations process personal data. Data security measures. Both laws mandate that organizations implement adequate technical and organizational measures to secure personal data from unauthorized access or breaches. Data breach notification. Both GDPR and the DPDP Act require that organizations notify the relevant authorities and affected data subjects within a specific timeframe when a data breach occurs. Key differences. Scope of application. GDPR applies to any organization processing the personal data of EU residents, regardless of where the organization is located. DPDP Act applies primarily to Indian organizations processing the personal data of Indian citizens. However, it also applies to data processing outside India if the data is related to offering goods or services to Indian residents. Penalties for non-compliance. GDPR. Penalties can be as high as 20 million euros or 4% of global turnover, whichever is higher. DPDP Act. Penalties can be up to 250 crore, around 30 million, depending on the severity of the violation. Children's data protection. GDPR prohibits the processing of children's data under 16 unless parental consent is obtained. DPDP Act sets the age of a child at under 18, requiring parental consent for the processing of children's data. Data localization. GDPR does not mandate data localization, but imposes strict conditions for cross-border data transfers. DPDP Act requires certain sensitive data to be stored and processed within India, promoting data localization. Enforcement authority. GDPR. Enforcement is carried out by independent supervisory authorities in each EU member state. DPDP Act. The Data Protection Board is established for enforcement in India, and there is an appellate mechanism through an appellate tribunal. Key takeaways. Global standards. GDPR has set the benchmark for data protection laws globally. Its principles have influenced laws in other regions, including the US, CCPA, Brazil, LGPD, and India, DPDP Act. Data subject rights. Both GDPR and the DPDP Act emphasize protecting individuals' data rights, such as the right to access, correct, and delete personal data. Penalties for non-compliance. Both frameworks impose significant penalties to ensure organizations take data protection seriously. Jurisdictional differences. The DPDP Act is more focused on Indian citizens, with provisions for data localization, while the GDPR is global in scope. In the next chapter, we will dive into the importance of data protection in the digital age, focusing on its key provisions, the privacy concerns and cybersecurity risks, and the impact of data breaches and cyber attacks under the Act. Thank you for joining this session. In the next lesson, we will explore the importance of data protection in the digital age, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.